For millions of lawful permanent residents across the world, the United States green card represents far more than just a piece of plastic. It represents years of sacrifice, long immigration processes, family separation, financial investment, hope, and the dream of building a stable future in America. But what many green card holders do not fully realize is that permanent residency comes with responsibilities, and one of the biggest responsibilities is maintaining the United States as your true permanent home. As of May 2026, immigration authorities, including USCIS and Customs and Border Protection, are paying extremely close attention to green card holders who spend long periods of time outside the United States. And if you are someone who frequently travels abroad, stays overseas for months at a time, cares for family members outside the country, manages businesses overseas, or even plans to temporarily relocate for personal reasons, this video could be one of the most important videos you watch this year. Because today, we are going to break down exactly how long a green card holder can stay outside the United States, what risks begin after 6 months abroad, what happens after 1 year, how re-entry permits work, how taxes affect your case, how USCIS evaluates abandonment of residency, and the exact steps you should take to protect your immigration future. Stay with us until the end because we are also going to walk through real-life examples that show how some green card holders successfully protected their residency while others unknowingly placed themselves in danger of losing it. The first thing every permanent resident needs to understand is that a green card is based on the idea of permanent residence. That word permanent is extremely important. When the U.S. government grants someone lawful permanent resident status, it is doing so with the expectation that the United States will become that person's primary home. A green card is not designed for someone who wants to live mostly in another country while occasionally visiting America. It is meant for individuals whose life is centered in the United States. That means your home, your employment, your taxes, your financial activity, your family ties, and your long-term plans are expected to be connected primarily to America. Many people mistakenly believe there is a simple rule saying you can stay outside the United States for up to 6 months without any issue, and that briefly returning automatically resets everything. But immigration law is far more nuanced than that. USCIS and CBP officers do not simply count days in isolation. They examine patterns, they evaluate intent, and they look at the total picture of your life to determine whether you have truly maintained your permanent residence in the United States. Now let us talk about the famous 6-month rule, because this is where confusion begins for many green card holders. Generally speaking, if a lawful permanent resident travels outside the United States and returns within less than 6 months, CBP officers at the airport or border crossing are less likely to question the person extensively about abandonment of residence. Trips under 6 months are typically viewed as temporary in nature. However, this does not mean you are completely immune from questioning. CBP officers still have authority to ask about your travel history, your employment, where you live, and whether your life is genuinely centered in America. And here is something extremely important that many people do not understand. Returning to the United States for just a few days before leaving again does not magically erase concerns about abandonment. Immigration officers look closely at patterns of repeated long absences interrupted only by very short visits back to the United States. If your travel history shows that you spend most of your year living abroad and only briefly enter the United States to maintain appearances, that pattern itself can become evidence that you no longer truly reside in America permanently. Things become more serious once a single trip extends beyond 6 months. At that point, immigration officers may begin questioning whether your continuous residence has been interrupted. A trip lasting more than 6 months but less than 1 year does not automatically cancel your green card, but it absolutely increases scrutiny. When you arrive at a U.S. airport after being abroad for 7 months, 8 months, or 10 months, you may be directed into secondary inspection, where CBP officers can ask detailed questions about your ties to the United States. They may ask where you maintain your home, whether you pay rent or a mortgage in America, whether your spouse or children live in the United States, whether your children attend American schools, whether you maintain U.S. bank accounts, whether you file U.S. taxes every year, whether you maintain employment in the United States, and even where your car is registered. These questions are not random. Officers are trying to determine whether your absence was truly temporary or whether your actual life has shifted to another country. One of the biggest mistakes green card holders make is assuming that owning property in America automatically protects them. That is not always true.
Imagine someone who owns a house in the United States but rents it out to tenants while spending nearly all their time abroad. That alone may not convince USCIS that America remains their permanent residence. Immigration officers examine the full context of your life. Where do you actually spend your time? Where is your primary social and economic life located? Which country feels like your true home based on your actions? Those are the deeper questions officers consider during inspections and immigration proceedings. Now we need to discuss what happens after 1 full year outside the United States, because this is where the risks become extremely serious. If a green card holder remains outside the United States for more than 12 consecutive months without special authorization, immigration officers may conclude that the individual abandoned permanent residency entirely. In many cases, when someone returns after more than 1 year abroad, CBP officers may ask the person to sign Form I-407, officially called the Record of Abandonment of Lawful Permanent Resident Status. This form is essentially a voluntary surrender of your green card. And here is the critical fact many people never realize until it is too late. You are not legally required to sign Form I-407. Officers may present it as if signing is routine or expected, but signing that document voluntarily gives up your permanent resident status. If you ever face that situation, you have the right to request a hearing before an immigration judge instead of immediately surrendering your green card. Never sign any immigration document you do not fully understand, especially during stressful airport inspections after long international travel. Fortunately, there is an extremely important tool available for green card holders who know in advance that they may need extended time outside the United States. It is called a reentry permit, filed using Form I-131 through USCIS. This document can be one of the most valuable protections available to permanent residents. A reentry permit allows a green card holder to remain outside the United States for up to 2 years without automatically being considered to have abandoned residency. This can be critically important for individuals caring for sick family members abroad, handling business matters overseas, pursuing temporary work assignments, managing family emergencies, or dealing with unexpected life situations. However, many people fail to apply for a reentry permit simply because they do not know it exists until after problems arise. There are several important rules about reentry permits that every green card holder should know. First, you must apply for the permit while physically present inside the United States. You cannot wait until you are already overseas. Second, USCIS requires biometrics, including fingerprints and photographs, and those appointments also take place inside the United States. Once your biometrics are completed, you are generally allowed to travel abroad while USCIS continues processing the application. Many applicants choose to have the completed reentry permit mailed either to a trusted U.S. address or to a U.S. embassy or consulate abroad. But because USCIS processing times constantly change, it is extremely important to check official USCIS guidance before making travel plans. Taxes are another major issue that many green card holders underestimate. Under U.S. law, lawful permanent residents are generally required to file U.S. federal income tax returns every year, reporting worldwide income regardless of where they physically live. Some green card holders mistakenly stop filing taxes after moving abroad temporarily because they believe they no longer earn enough in the United States to matter. That can become a serious problem later. During immigration reviews, tax filings are often examined as evidence of whether someone truly maintained U.S. residency. Filing taxes as a non-resident or failing to file at all may be used as evidence that you no longer consider the United States your permanent home. Immigration law and tax law intersect in powerful ways, and ignoring taxes can create immigration consequences years later when applying for citizenship, renewing a green card, or re-entering the country after extended travel. Consider a situation where a green card holder leaves America to care for an elderly parent overseas. The person initially plans to stay for 3 months, but family medical complications extend the trip to 14 months. Upon returning to the United States, the traveler is questioned extensively by CBP. However, because the individual maintained a U.S. apartment, filed U.S. taxes, kept American bank accounts, and documented the family emergency with medical records, officers may still determine the absence was temporary rather than an abandonment of residency. This demonstrates why documentation matters so much. Evidence can make the difference between protecting your green card and losing it. Now imagine a completely different scenario involving a permanent resident who spends most of the year living overseas while only briefly visiting the United States once or twice annually. Over time, the person stops filing U.S. taxes, closes American bank accounts, and gradually builds a life abroad instead. Years later, during a green card renewal or citizenship application, USCIS reviews travel records and notices the pattern. Long absences, weak U.S. ties, missing tax returns, and a lifestyle centered abroad can collectively create strong evidence that permanent residency was effectively abandoned long ago. Many people are shocked when immigration problems appear years after their travel patterns began, but USCIS often reviews long-term history very carefully. Another critical topic green card holders must understand is how international travel affects naturalization and U.S. citizenship eligibility. Even if you successfully maintain your green card status, long absences abroad can still interrupt the continuous residence required needed for citizenship. In most cases, lawful permanent residents must demonstrate 5 years of continuous residence before applying for naturalization, or 3 years if married to a U.S. citizen. Trips longer than 6 months may create a presumption that continuous residence was broken. Trips longer than 1 year almost always disrupt the continuous residence requirement unless special exceptions apply. That means someone hoping to become a U.S. citizen could unintentionally delay their eligibility for years simply because of extended travel abroad. So what should green card holders do right now to protect themselves? First, review your travel history carefully. Look at every trip taken over the past several years and calculate how much time you spent outside the United States. If you notice repeated long absences, understand that immigration officers may notice those patterns too. Second, strengthen and document your ties to America. Maintain housing, bank accounts, tax filings, employment records, utility bills, driver's licenses, insurance policies, and other evidence showing that the United States remains your true home. Third, if you anticipate extended travel abroad, speak with an experienced immigration attorney before leaving and discuss whether a re-entry permit is appropriate. Fourth, never ignore immigration paperwork or border inspections. If questioned by CBP, remain calm, truthful, and organized. And finally, always stay informed using official government sources, because immigration policies, processing times, and enforcement priorities can change over time. At the end of the day, your green card is more than just an immigration document. It represents opportunity, stability, and the possibility of building a future in America. But permanent residency carries obligations as well as benefits. Long absences abroad are not automatically forbidden, but they must be handled carefully, strategically, and responsibly. The U.S. government expects permanent residents to genuinely maintain America